The letter came on a Tuesday, tucked between a pizza coupon and my electric bill, and it had my name typed in bold on the front. In re, the guardianship of Mara Elaine Whitfield. I stood in my own hallway in my own house, holding a legal document that said, in plain language, that my parents wanted a judge to declare me incompetent to manage my own life. My hands were shaking so hard I had to set it down on the kitchen counter and read it twice just to be sure I wasn't misunderstanding a word. I wasn't. My mother, Diane Whitfield, and my father, Roger Whitfield, had filed a petition in Multnomah County Probate Court asking to be named my legal guardians and conservators, meaning they wanted the court to hand them control over my finances, my medical decisions, and if they got their way, my ability to sign a lease, open a bank account, or say no to anything they decided was best for me. I was 34 years old, I had a mortgage, I had a job I'd held for 9 years, I had never been arrested, never missed a car payment, never done anything you'd call reckless in my adult life. And 2 days later, sitting in a stiff chair across from a lawyer I'd hired in a panic, I learned exactly why they thought they could pull this off. 18 months earlier, my grandmother Alina had died and left me the lake house in Hood River and a trust worth just over $340,000. Not my mother, not my father, not my younger brother Connor, me, and that's the part I want you to sit with for a second because it's the part that made this whole nightmare make sense. This was never about my mental health. It was about the money my grandmother decided I deserved and they didn't. Quick question before I keep going, where are you watching this from tonight, and is it as late where you are as it is here? I always like knowing who's sitting with me for these, because here's the thing about my family, they didn't come at me with anger, they came at me with paperwork. And paperwork, when you don't know how to read it, can look a lot like the truth. To understand how they thought this could work, you have to know what happened when I was 26. I'd had a bad 2 years. My engagement fell apart, I lost a job I loved when the company downsized, and I stopped sleeping right for about 4 months straight. I went to see a psychiatrist named Dr. Patricia Yoon, and for a stretch of about 6 weeks, I was on a treatment plan that included a short voluntary stay, 5 days, at a behavioral health facility outside Portland. After I told my therapist at the time I was having thoughts I didn't feel safe having alone. That was 8 years before the envelope showed up on my counter. I'd been stable since. I had years of records showing steady work, no hospitalizations, no incidents, nothing. I'd built an actual life. I'd built it carefully, the way you build something back after it's been broken once, brick by brick, therapy appointment by therapy appointment, paycheck by paycheck. But my mother had never let go of those 5 days in my 20s. She brought them up at holidays. She brought them up when I disagreed with her about anything. And now, apparently, she'd brought them up to a lawyer, framed in a way that made a difficult chapter of my life sound like an ongoing crisis instead of something I'd walked through and out of nearly a decade ago. The petition cited a documented history of psychiatric hospitalization and instability, and claimed I had recently exhibited erratic financial decision-making inconsistent with sound judgment, including, and I want you to hear how absurd this sounds, buying a car. A used Honda CR-V, paid for in full with money from my own trust because my 10-year-old sedan had a transmission that was on its last legs. That was their evidence. A hospitalization from when I was 26 and a Honda. My lawyer, a calm, sharp-eyed woman named Renata Ibarra, read the petition twice and then looked up at me and said something I've never forgotten. This isn't a strong case on the facts, which means it's not really about winning. It's about pressure. I didn't understand what she meant yet. I would, within about 3 weeks. The first thing Renata had me do was request everything, every document my parents' lawyer had filed, every exhibit, every affidavit attached to the petition. Discovery, she called it. I called it the worst reading assignment of my life. Buried in the exhibits was an affidavit from my brother Connor. 2 full pages, describing conversations we'd supposedly had where I told him I was overwhelmed by the responsibility of managing that much money and wished someone else could just handle it for me. I read it standing in Renata's office, and something cold moved through my chest because I remembered the conversation he was twisting. It had happened at Thanksgiving, 7 months earlier. I'd said, tired and a little overwhelmed after doing my own taxes for the first time with trust income involved, that I wished I understood finance better and might look into hiring a fee-only financial advisor. That was it. That was the whole conversation. Connor had taken one offhand, very normal sentence and rebuilt it into a sworn statement suggesting I couldn't function. I hadn't expected my parents to come after me. I think some small, stubborn part of me had been braced for that since I was a teenager. Honestly, my mother and I had never been easy with each other. But Connor was 2 years younger than me. We weren't close exactly, but we weren't enemies either. We texted about football. He'd asked to borrow my truck to move a couch 4 months before this. Renata noticed my face and slid a legal pad toward me. Before you react, she said, I want you to think about why your brother would sign something like this. People don't usually do this for free. What does he need? I didn't have an answer that day. I got one 3 weeks later, and it came from a bank statement. Renata had subpoenaed financial disclosures related to the guardianship proposal, standard practice, since a proposed guardian has to show the court they're not conflicted or in financial distress themselves. My mother and father's disclosures came back mostly unremarkable. Connor's, attached because the petition named him as an alternate co-guardian if my parents were found unfit to serve alone, told a different story. Connor owed just under $61,000. A chunk of it was credit card debt from a failed food truck business he'd started 2 years earlier and quietly shut down. Another chunk was a personal loan from, and this is the part that made my stomach drop, our parents. $18,000, informally documented in a single email from my father with the subject line loan terms, dated 11 months before the guardianship petition was filed. Suddenly the affidavit made a different kind of sense. If my parents became my guardians, they would control the trust. If they controlled the trust, they controlled how and whether Connor's debt to them ever got repaid, and possibly how much additional family support flowed his way quietly under the umbrella of managing my finances for my own good. He hadn't lied for nothing. He'd lied because he needed them to win. I sat with that for a long time. I want to be honest with you, even knowing what I knew, I didn't hate him in that moment. I felt something closer to grief. My brother was drowning in a debt he was too proud to admit to me directly, and instead of asking me for help, he'd help try to take away my right to make my own decisions. Renata was more clinical about it. This gives us motive, she said. Motive is good. It's not enough on its own, but it's good. What we needed, she told me, was to take apart the actual medical claim at the center of the petition, the idea that I was presently, demonstrably unfit. And for that, we needed my own psychiatric history to work for me instead of against me. We needed Dr. Yoon. I hadn't spoken to Dr. Patricia Yoon in almost 3 years. I'd graduated out of regular sessions with her back when things had stabilized, moved to a general practitioner for occasional check-ins, and we'd lost touch the ordinary way people do when they no longer need each other in the same way. Calling her felt like reopening a door I'd shut carefully and on purpose. I remember sitting in my car outside her old office building. She'd since moved practices for almost 20 minutes before I dialed. When I finally got her on the phone and explained what was happening, there was a long pause. Then she said quietly, Mara, I want you to know something. I've had 2 calls this month about you that I didn't return. My whole body went still. Calls from who? Your mother, she said. Twice. Once asking me to provide a written statement supporting a guardianship petition, and once, after I declined the first time, asking if I would at least confirm you'd once been hospitalized, since that information, she said, was already part of the public record. It wasn't public record. Not really, not in any way that should have been usable without my consent, but my mother didn't need it to be entirely accurate. She needed it to sound official enough to make a judge pause. Dr. Yoon told me she'd told my mother both times that she couldn't discuss my care without my authorization, full stop, and that continuing to call would be noted. She also told me something that mattered more than anything else in that conversation. She still had my complete file, 8 years of it. Every session note, every discharge summary, every follow-up assessment showing stability, consistency, and her words, someone who did the hard, unglamorous work of getting better and stayed better. If you want me to testify, she said, I will tell them exactly what's in that file. All of it, the hard parts and the recovery. I won't hide either one, and I don't think you should want me to. That was the moment the case stopped feeling like something happening to me and started feeling like something I could actually fight. Before we got anywhere near a hearing, the court ordered what's called an independent capacity evaluation. A neutral, court-appointed psychologist would assess me and file a report with the judge. My parents' lawyer, a smooth, silver-haired man named Gerald Prohaska, seemed almost pleased about this. Renata told me later she suspected they were counting on the evaluator finding anything they could spin. The evaluation took place over 2 sessions with a psychologist named Dr. Amrita Desai, who had no connection to my family, my parents' lawyer, or Dr. Yoon. She asked about my job, my finances, my daily routine, my relationships, my history. She asked hard, direct questions about the hospitalization when I was 26, not to trap me, but because it was relevant and she wasn't going to pretend it wasn't. I answered everything honestly. I told her what had led to that point in my life, what treatment had looked like, what had changed since. I told her about my job managing design projects for a mid-sized marketing firm, about the budget I kept for the trust with the actual financial advisor I'd hired, the one Connor's affidavit had twisted into evidence of instability, and about the CRV, which I'd bought after getting 3 separate mechanic quotes confirming my old car's transmission was failing. 3 weeks later, Dr. Desai's report landed. It was 11 pages long, and it found, in careful clinical language, no evidence of any current impairment in judgment, reasoning, financial decision-making, or daily functioning. It noted my psychiatric history accurately and without alarm, describing it as a resolved episode with sustained recovery of over 8 years, well documented and consistent with the standard for full legal capacity. It was a gut punch for my parents' case. But it wasn't the end of it. Because 2 days after that report was filed, Gerald Prohaska filed something else, a supplemental letter, supposedly from a different treating physician, suggesting I'd had a concerning episode far more recently than anyone had mentioned. The letter said I'd been seen at an urgent care clinic 11 months earlier for what it called an acute anxiety crisis with disorientation. I had never been to that clinic, not once in my life. Renata went very quiet reading that letter, and quiet, I'd learned by then, was not a good sign from her. It meant she was thinking hard, not that everything was fine. "Do you remember any urgent care visit last spring?" she asked. I hadn't been sick. I hadn't been anywhere near urgent care in years beyond a sprained ankle from a hiking trip, and that had been a different clinic entirely, 2 years before the date on this letter. We requested the underlying medical records the letter claimed to summarize. It took 9 days and 2 follow-up requests before the clinic's records department responded, and when they did, the record they sent back showed a visit, but not from me. The patient's date of birth on the chart was off by 4 years from mine. The address on file was an apartment complex I'd never lived in a part of town I'd never lived in. There was a phone number that wasn't mine. It was a different Mara Whitfield. Or possibly not even that, possibly a records mix-up, a chart mislabeled at intake, the kind of clerical error that happens more than anyone likes to admit in overworked clinics. Whatever the cause, one thing was clear. The physician's letter attached to my parents' filing had either been carelessly based on someone else's chart or deliberately built around it, because the record didn't match me on a single identifying detail once you actually looked. Renata requested the original intake paperwork with the physician's own signature, and, critically, the metadata showing when the supplemental letter itself had been created and edited. It had been drafted 9 days after my mother's second phone call to Dr. Yoon, the one where she'd been told flatly no. We couldn't prove, not with total certainty, exactly how that mismatched chart had ended up attached to a letter about me. But we could prove, document by document, that the evidence at the emotional center of my parents' supplemental filing didn't hold together. And we could prove the timing looked less like an honest mistake and more like someone scrambling for anything usable after Dr. Yoon shut the door. Renata filed a motion asking the court to strike the supplemental letter and requested sanctions for what she characterized, carefully, as material submitted without adequate verification. The hearing where that motion would be argued was set for 6 weeks out. Those 6 weeks were some of the hardest of my life, not because anything dramatic happened, but because nothing did. I went to work. I answered emails about a rebrand for a client's coffee chain. I made dinner. I lay awake at 3 in the morning more nights than I want to admit, staring at the ceiling, wondering how my own mother had ended up here. About 4 weeks before the hearing, my father called me. Not my mother, my father, which was itself unusual because in my family my mother had always been the one who spoke and my father was the one who went along. He asked to meet for coffee. Against Renata's mild advice, she said I could go, just not to discuss the case in detail and to let her know immediately if anything relevant came up. I went. He looked older than I remembered, though it had only been 4 months since I'd seen him at all. He didn't apologize, not exactly. What he did was tell me, haltingly, that this had started as your mother's idea, and I went along with it because I didn't know how to tell her no, and I'm asking myself now whether that's ever been true about anything in our marriage. He told me my mother had never forgiven my grandmother, her own mother-in-law, for the way the will was writ. Eleanor had left small keepsake amounts to my parents and Connor, and the bulk of the estate to me, along with a handwritten letter, which I'd never shown my family, in which she explained that she trusted me to be careful with money in a way she worried the rest of the family wasn't, and that she hoped I'd use some of it to build a life that felt stable and mine. My mother had read a copy of that letter. My grandmother's attorney had sent one to the whole family as part of the estate disclosure, and according to my father had never spoken about it again except once, months later, late at night, when she'd said, "She thinks I raised a daughter who can't be trusted and a son who can't be helped." Well, we'll see. My father said it like a confession, like something that had been sitting in him for over a year. He said the guardianship idea had come from a conversation with an old college friend of my mother's who worked in elder law, someone she'd reached out to initially about Connor's debt, and the conversation had somehow turned into this. He didn't ask me to drop the case. He said he understood if I couldn't. But he wanted me to know that whatever happened at the hearing, he didn't think I was unfit, and he was ashamed it had taken him this long to say it to my face instead of just going along with your mother, the way I always have. I believed him. I also didn't fully forgive him, not that day. Both of those things were true at once. 2 weeks before the hearing, Connor called me. I almost didn't pick up. He was crying before he'd said more than my name, which was so unlike him that I actually sat down on my kitchen floor to listen, because I didn't trust my legs to hold me through whatever was coming. He told me he'd recorded a conversation with our mother, back in the fall, at a point when he was having second thoughts about the affidavit she'd asked him to sign. He said he'd recorded it because some part of him already knew he might need proof someday of what he'd actually been asked to do, proof for himself, if nothing else, that he hadn't imagined the pressure. In the recording, which he sent to Renata that same night, my mother's voice is unmistakable. She tells Connor that nobody's going to actually hurt Mara, this is just paperwork, that the trust should have been split fairly to begin with, and the sentence that ended up mattering most in front of a judge, once we're managing it properly, there's no reason you can't be reimbursed for what you're owed. That's not stealing, that's fairness. Connor told me he hadn't sent it sooner because he was scared. Scared of our mother, scared of what it would mean about himself if he admitted what he'd done, scared, he said, of finding out I really am the kind of person who'd do that to his own sister for money. I didn't tell him it was fine. It wasn't fine, but I told him I was glad he sent it and that whatever happened next between us, that mattered. Renata was more measured when I brought her the recording. Oregon is a two-party consent state for recorded conversations, meaning both people generally have to agree to being recorded for it to be used, and Connor hadn't gotten our mother's consent. It couldn't simply be played as courtroom evidence the way I'd hoped. But it wasn't useless. Renata explained that it could inform strategy, help us know exactly what my mother's stated reasoning was so we could ask precisely the right questions under oath, questions she wouldn't be expecting, because she wouldn't know we already knew the answer. This is how these cases actually get won, Renata told me, not with one big dramatic moment. With enough small, verified pieces that a judge can't find a version of events that makes sense except the true one. The hearing took place over 2 days in a courtroom that looked nothing like television, fluorescent lights, beige walls. A judge named the Honorable Denise Ackefer, who wore reading glasses low on her nose, and interrupted lawyers the moment they started to grandstand. Gerald Prohaska opened for my parents by leaning hard on the original hospitalization, on my unusual cash purchase of a vehicle, and on what he called a family's legitimate, loving concern for a daughter who has struggled before and may struggle again. Renata's opening was shorter. She said the court would hear from an independent, court-appointed evaluator who found no impairment whatsoever, from a treating psychiatrist with 8 years of documentation showing sustained stability, and from financial records showing exactly who in this family was actually in financial distress, and it wasn't me. Dr. Desai testified first, walking the judge through her 11-page evaluation calmly and without a hint of bias in either direction. Under cross-examination, Prohaska tried to make the hospitalization sound recent and unresolved. Dr. Desai corrected him precisely. That episode occurred 8 years and 2 months ago. There is no clinical basis in my evaluation or in the records I reviewed to suggest ongoing impairment. Recovery of this duration and consistency is clinically exactly what stability looks like. Then it was Dr. Yoon's turn. I want to tell you honestly, I'd built this moment up so much in my head that I was almost afraid it couldn't live up to what I needed it to be. It did. Dr. Yoon sat in the witness chair with my complete treatment file in front of her, 8 years of notes, and she did not soften a single true thing. She described plainly what I'd gone through at 26. The sleeplessness, the depression following my broken engagement and job loss, the 5-day voluntary stay, the medication adjustments in the year that followed, the gradual, unglamorous work of therapy that continued for years after. Then she described what came after that. Weekly sessions tapering to bi-weekly, then monthly, then 3 years in, a mutual decision to conclude regular treatment because I had met every marker of sustained recovery, stable employment, stable housing, healthy relationships, no further crises, consistent follow-through on every recommendation given to me. Prohaska tried carefully to suggest that the 2 phone calls from my mother meant Dr. Yoon had reason to be concerned recently. Dr. Yoon didn't take the bait. Mrs. Whitfield called asking me to help build a case against her daughter's competence, she said evenly. I found that request, frankly, concerning, but not because of anything in Mara's file. Because of what it suggested about the pressure being placed on her from within her own family. Then Renata asked her the question we'd built the whole day toward. In your professional opinion, based on 8 years of direct clinical observation, is Mara Whitfield currently capable of managing her own financial and medical affairs? Without question, Dr. Yoon said. I would go further. In 8 years of practice, I have rarely seen a patient do the work of recovery as thoroughly and consistently as she has. Whatever brought this family to a courtroom, it is not a mental health crisis. There isn't one. There hasn't been one in a very long time. I cried in the courtroom. I'm not going to pretend I didn't. Judge Okafor also heard testimony about the mismatched urgent care record, about Connor's debt to our parents, about the timeline of the supplemental letter's creation. Prohaska's attempt to explain the clinic letter as an honest mix-up didn't survive Renata's cross-examination, which walked through, date by date, exactly how implausible that explanation was given when the letter had been drafted. My mother testified last. Under oath, asked directly why she believed guardianship was necessary. She gave an answer that didn't reference any actual incident, any actual behavior, any actual evidence, just a vague, repeated insistence that she knew her daughter and wanted to protect the family. When Renata asked her plainly whether she had discussed reimbursing Connor's debt to her and my father out of trust funds she would control as guardian, my mother paused for 11 long seconds before saying, that would have been a family decision, not a certainty. It wasn't a confession. But it wasn't nothing, either. Judge Okafor didn't rule from the bench that day. She took it under advisement, which Renata told me was normal but which still made the following 9 days feel unbearable. When the ruling came, it was unambiguous. The court found no clear and convincing evidence, the legal standard required, that I lacked capacity to manage my own affairs. The petition for guardianship and conservatorship was denied in full. The judge specifically noted, in her written opinion, concerns regarding the reliability and provenance of certain medical documentation submitted in support of the petition, and referred the matter of the mismatched clinic letter for further review, though she stopped short of imposing sanctions, citing insufficient proof of intentional fabrication versus negligent error. I was legally exactly what I had been the whole time, a competent adult in full control of my own life. It didn't feel like winning, not in the way I'd imagined it would during those sleepless nights. It felt like exhaustion mostly. Relief, but heavy relief, the kind that comes after you've been holding your breath so long you forgot what normal breathing felt like. I didn't speak to my mother for almost 5 months after the ruling. When we did finally talk, it was a short, careful phone call, not a reconciliation so much as an acknowledgement that we were both still alive and still, technically, family. She has never apologized in the way I once thought I needed her to. What she said more than once now is that she did what she thought was necessary, which isn't an apology, but I've stopped waiting for one to feel like I can move forward. My father and I talk more now than we ever did before this happened, in a strange, sideways kind of way. I think shame did something to him that fear never could. He started seeing a therapist of his own, something I never imagined him doing when I was growing up. Connor and I are rebuilding slowly. I helped him find a credit counselor instead of handing him money directly, Renata's advice actually, and good advice. He's paying down the debt on his own terms now, not our parents'. We talk every couple of weeks. It's not what it was before any of this, and it might never be, but it's something real, which is more than I can say for a lot of what came before. I still own the lake house. I still have the trust, managed now by the financial advisor I hired myself, the same one whose existence had once been twisted into evidence against me. I go up to Hood River sometimes on weekends, alone, and I sit on the dock my grandmother used to sit on, and I think about the letter she wrote me, the one that said she trusted me to be careful with what she left behind. I am. That was always true, whether or not anyone in a courtroom needed a psychologist to say it out loud. People ask me sometimes, now that it's over, whether I regret fighting it, whether it would have been easier to just let my parents have some control, keep the peace, avoid the courtroom and the legal bills and the 11-second pause where my mother almost admitted the truth. I don't regret it, not for a second. Because what they were really asking a judge to take from me wasn't money. It was the basic presumption, the one every adult is supposed to be allowed to carry through their life, that I know my own mind. That presumption is worth fighting for, even against your own family. Especially against your own family, maybe, because if the people who raised you don't believe you're capable of running your own life, it's easy to start doubting it yourself. I didn't doubt it, not in the end, and I think that's the part I'm proudest of. This story is a work of fiction created for entertainment and reflection. Any resemblance to real individuals or events is coincidental. If this story meant something to you, the takeaway I'd leave you with is simple. Being loved by your family and being controlled by your family are not the same thing, and you're allowed to know the difference.